Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee. Welcome, everyone, to this week's episode of IPWatchdog Unleashed. This week, I don't have a guest joining me. As fate would have it, the two podcast conversations I had planned for the week were both postponed, leaving me with a short window to figure out what to do. Undeterred, I thought I would take this opportunity to provide my thoughts on the use, limitations, and future for artificial intelligence in our industry. I keep hearing that AI is going to eliminate patent lawyers. I don't think that's quite right, or at least it certainly isn't the entire story. First, it's worth noting that despite virtually every new technology being predicted to cut jobs, that has never happened. Sure, it is certainly true that new technologies often require new skill sets, and those who do not have the proper education or training do struggle unless and until they are willing to learn new skills. But the overall number of jobs does not decrease when technologies are introduced. This is because new technologies create new opportunities, including opportunities that were prohibitively expensive or just too time-consuming. So our collective experience throughout history is that new technology leads to new jobs, new opportunities, and new potential. In my opinion, AI promises to be no different, although uneducated workers may need to find different, less appealing work. But that isn't the subject at hand for us, and it isn't the patent industry. Those in the patent field are not uneducated or untrained, and even those who lack knowledge of using AI today can absolutely learn new skills required to do so. After all, we are patent professionals, and that means on some level, we're extremely educated, possess a high degree of intelligence, and at our core, we are engineers, scientists, and technologists. With a little bit of interest and a little bit of effort, everyone in our industry will be fine. Having said that, there is little doubt that AI is going to eliminate some patent work. AI is already making some work dramatically faster. AI is going to change how law firm staff matters, how clients evaluate outside counsel, and what clients are willing to pay for routine services. But I do not believe AI is going to eliminate experienced patent lawyers who provide real judgment and strategic value. Instead, what AI will do is expose the patent professionals whose value proposition consists primarily of producing a commodity work product, whether that is through performing routine searches, engaging in a factory production line style application drafting mill, or tediously incremental prosecution that is never really thoughtfully intended to result in allowance or even gain any useful insight into the examiner's thought process. In other words, rinse and repeat thoughtless work won't allow patent professionals to charge professional rates for work that is increasingly commoditized. For some, this will be an uncomfortable prediction, but this is a prediction that is easy to make and one I say with great confidence. The handwriting is on the wall. Those who adapt will not only survive but thrive. Those who resist will either retire or condemn themselves to a different line of work altogether. And while experienced patent practitioners have a choice, the gravitational push of AI towards higher-level, thoughtful, and strategic work raises an important question. If AI is going to perform much of the work traditionally assigned to junior lawyers, patent agents, and searchers, how are younger professionals going to gain the experience necessary to use AI responsibly and effectively? That may be the most important question we're going to discuss today. AI is already very good at a number of patent-related tasks that have often been viewed as entry-level positions or at least as on-ramps into the industry. AI can search prior art, it can summarize references, it can compare claims, it can identify potentially relevant limitations, it can help draft specifications, it can help draft claims, it can prepare first office action responses, it can identify inconsistencies in a patent application, and it can analyze a portfolio. None of that means that AI can do any of that work competently without a human involved, though. It would be foolish to treat AI as a magic button, as we've witnessed when litigators around the country have asked AI to draft briefs, which wind up full of fictitious cases and propositions of law that are just flat wrong. But the realization that AI needs oversight and can't produce file-ready work product doesn't sound very much different from a new associate fresh out of law school, or even an associate with years of experience who just isn't ready to fly solo yet. And that's not a dig either at AI or the inexperienced associate. We've all been there. I know I hate thinking about what I was producing fresh out of law school. We all go through growing pains on our way to competence and then hopefully ultimately mastery. And AI is a tool. Maybe someday it will be much more, but today and for the foreseeable future, it is a tool. A sophisticated tool, but just a tool. And while AI needs supervision, ignoring the reality that industry economics and the workflow of patent practice are changing would be naive, to put it politely. AI is already remarkably good with a closed universe of documents, which doesn't even really need to be a small closed universe. Ask it which one of the documents it has access to in the closed universe that are the closest to what you're looking for, and it's going to perform that task with shocking ability. Ask it what in one document is different compared to another document, or even a set of documents, and it will be shockingly good at that as well. And fundamentally, this is the work of a professional searcher, and at least a first leg on the way to either a patentability opinion or a freedom to operate. So already today, AI is exceptional at pieces of the patent practice deliverable. If you ask it to draft the patent application, it is less good at that, although practitioners who are power users of AI will tell you that if you define a discrete task, the tools are very good at that as well. Without context and asking for AI to draft the patent application, that isn't going to lead to something very useful, but piece by piece task assignment under the supervision of an experienced practitioner, and you will get a very workable and usable draft. So whether it's as a replacement for searching, or whether it is with supervised assistance when drafting applications or preparing office action responses, AI is already very good. And to put this into some more concrete terms, if 100% is the perfect filing that has achieved the point where it is optimal and cannot be improved even with additional time and effort, AI today can get you to the 95% solution in the same amount of time it used to take for professionals to get to the 80% solution. And if we're honest, even very high-end patent work prior to AI never achieved 100%. A point of diminishing returns always happens in every project, and that together with client budgets means no one ever did file something that was perfect and couldn't be made better. I've always told clients that I won't run out of the ability to make something better, but at some point you will run out of the budget to pay me to make what are increasingly marginal incremental improvements. So the 80% solution has historically been the sweet spot where additional incremental improvements are so marginal given the additional cost and time, it just doesn't make sense to continue to iterate. And that worked for decades. But if you're paying attention, the Federal Circuit, Patent Trial and Appeal Board, and the district courts think historically acceptable levels of effort and disclosure are no longer enough. This means many in the industry are missing the point entirely, particularly in-house counsel, who are starting to demand that outside counsel cut costs because they're using AI tools. If you want to pay less, fine, I guess, but if you pay less, you're going to get less attorney time, and at least until AI does become a magic button, you will still at best only get to the 80% solution, if that. And this should be alarming because we know what the courts think, and they are constantly demanding more, not less. So if you force too much of a haircut on your outside counsel, even with AI, you aren't going to get anywhere close to an appropriate filing based on 2026 sensibilities. Instead, the wiser answer is to use AI to get to that previously unattainable level of quality. The ability to get to that 95% solution in a reasonable and affordable time, which is far closer to perfection than anything previously possible within any rational budget, is a significant development. I know there'll be some that push back on this point, but the truth is, if you don't care about obtaining patent rights that are actually useful and keeping those rights after they're obtained, what are you doing in the first place? Why are you even filing if all you're going to do is acquire assets that won't stand the test of time and won't stand up to scrutiny? Sure, I know that in some areas of the patent industry, it still is a numbers game, such as with standard essential patents, for example. But pretty much everywhere else, it must be about quality, not patent counts. Continuing to view the patent industry as a game of global thermonuclear war, where the winner has the most warheads, is foolish. It wastes precious resources. It isn't calculated to succeed at anything other than paying unnecessary fees. And when you really need an asset, it'll be nothing more than a paper tagger that won't survive the first challenge. Clearly, there is a better way to move forward. And the value of AI is not simply allowing a lawyer to produce more patents faster. The value is it may allow a lawyer to produce better patents, better analysis, and better strategic advice in the same amount of time. But there's a catch. As I mentioned earlier, AI is not a magic button. It is easy to imagine an AI system combining two embodiments from a patent disclosure and presenting the combination as a workable alternative. It may sound perfectly plausible, but the illustrative example may rely on incompatible operating conditions, different materials, or mutually exclusive configurations. A patent professional unfamiliar with the technology may never realize that the proposed embodiment simply can't work. And truthfully, we don't need to imagine that happening. Those in the industry who use AI report this very phenomenon actually happening. Sure, AI tools are rapidly getting better, but AI still gets a lot wrong. Use it enough and it will generate embodiments and illustrative examples that don't work. It will propose combinations that are technically impossible. It will combine elements from working embodiments in a way the inventor never conceived. And it can also confidently state that a reference teaches something that it does not teach, or create a seemingly plausible explanation that collapses as soon as someone with technical knowledge examines it. And this is where and why experience matters. An experienced patent lawyer understands that a polished sentence may still be nonsense, either legally or scientifically, or both. An experienced patent practitioner asks whether the proposed embodiment actually works. Was it tested? Was it conceived by the inventor? Is it supported by the specification? Does the disclosure enable the full scope of the claim? Is the alleged improvement real? Does the claim cover something commercially important? Would a skilled engineer implement it in the way the application suggests, or can it be easily engineered around? Are there any substitutes? AI doesn't reliably know when to ask those questions. That isn't a criticism, it's simply the current reality of the technology. And the USPTO has made it clear that AI-assisted inventions are not categorically unpatentable, but the current framework does require human inventorship at all times. AI systems are tools. They're not inventors, and we can't treat them as such. That means the use of AI creates another issue that cannot simply be delegated to a machine, determining what the human inventor actually contributed and making sure that is what is claimed. Now, these are not abstract questions or academic considerations. They can create inventorship, disclosure, and downstream validity problems. What I'm saying is that AI can help us explore possibilities, but it cannot relieve us of the responsibility to determine what is true, what works, what was actually invented, and what the law permits us to claim. This brings me to the lawyers who are most vulnerable to AI. It is not necessarily the older lawyer, and it's not necessarily the younger lawyer. It's the patent lawyer who is primarily doing commodity work. This means the patent lawyer who files every invention disclosure without asking whether the invention strategically matters is at risk. The patent lawyer who equates a larger patent portfolio with a better patent portfolio is at risk. The patent lawyer who provides the same prosecution advice, regardless of the client's products, competitors, or business objectives, is at risk. The patent lawyer whose primary contribution is turning information into commoditized documents is at risk. That work will increasingly be assisted, accelerated, or even replaced by AI-enabled systems. But strategic patent work is different. Strategic patent work requires deciding what is worth protecting, what should remain a trade secret, where the commercial value really lies, how broad a claim can and should be, what competitors are likely to do, which continuation applications are justified and which will just eat up budget. and whether a patent is likely to matter in litigation, licensing, acquisition, or negotiation. AI can contribute to those decisions, no doubt, but it cannot own them. And that is why I believe experienced patent lawyers are not going to disappear. In many ways, AI will make the best even better. But experience is what allows the patent lawyer to interrogate the output of AI and make it so much better. AI may give you a sophisticated-looking answer, but experience helps you determine whether that answer deserves to be trusted or used on any level. But this creates a serious problem that is not being discussed enough in the industry. How do inexperienced patent lawyers gain experience if AI performs the work that traditionally gave them that experience in the first place? We all learn through repetition. Handle enough different issues, see enough cases through to the end, and you're ready. But this meant searching prior art, reading references, drafting claims, writing applications, preparing office action responses for review by a partner. We would watch senior lawyers revise our work. Eventually, we saw which arguments succeeded, which claims failed, and which drafting decisions created problems later. The process was not always efficient, but it was an apprenticeship, and it worked. If AI now performs the search, drafts the claims, writes the first office action response, summarizes the reference, and proposes inventor questions, a senior partner doesn't really need a junior professional anymore, or at least they will need far fewer junior professionals. But how are those juniors to become more capable? That means AI is creating a real risk, and those at the beginning of their career need new strategies and maybe a little bit more fortitude than we did when we were coming up the ranks. The problem, of course, is AI tools could produce a generation of patent professionals who are very good at editing AI output, but are not good at recognizing when the output is suboptimal or even outright wrong. They may be fast, what they produce may look polished, but they may not understand the legal, technical, and strategic consequences of the work they're producing, and there may not be anyone to educate them. That is not a criticism of younger lawyers or patent agents in any way. It's a training problem, and one that clients and firms need to spend more time thinking about. And despite what some law schools are doing, the answer is not to keep younger professionals away from AI. That would be short-sighted. They need to learn the technology and become as proficient with it as possible. They need to understand how to use it. They need to experiment with it. But they also need a deliberate path to judgment. So my first recommendation is simple. Learn the fundamentals. A younger patent professional should understand claim construction, written description, enablement, anticipation, obviousness, prosecution procedure, inventorship, confidentiality, and professional responsibility. Use AI as a tutor. Find a Federal Circuit case analyzing a patent in a technological area that you really understand. Ask AI to compare the claim constructions offered with the claim construction the Federal Circuit settled on. Ask AI to identify the strongest and weakest arguments. Then read the actual opinion and determine where the AI is incomplete or wrong and interrogate the AI. AI gets stuff wrong, but when pushed and you require it to respond, it usually does get better. And the purpose isn't to rely on AI here. It is to use it to brainstorm and help you as a young professional to understand the issues, rulings, problems, and requirements in a 360-degree comprehensive way. What I'm saying is simply this. Do not use AI to avoid learning the law. Use it to learn the law faster and more deeply. Because once upon a time, to get to the point where you were ready to fly solo on your own in patent practice, most would say you needed to handle the equivalent of 25 cases from start to finish. So use AI to get to that level of equivalent experience faster. Second, treat AI like a brilliant but unreliable junior associate. AI can be fast, creative, and extremely useful. It can also be confidently wrong. Every output should trigger questions. What assumptions were made? What facts were invented? What citations need to be verified? Which technical propositions came from the inventor? Which examples need to be confirmed? What would opposing counsel attack? What would the examiner say? What would a skeptical Federal Circuit panel or the PTAB say? If a younger professional cannot answer those questions, then they're not yet supervising AI. The AI is supervising them, which is going to end in disaster. Third, use AI to attack the work product. Do not only ask it to draft, ask the system to identify what could go wrong. For example, what limitations are unsupported? Where could the application fail under Section 101? What is the strongest obviousness combination? What would a competitor do to design around this claim? Which portions of the disclosure appear to be speculative? What additional information must I obtain from the inventor? Are these claims legally possible but commercially useless? That kind of interaction is going to develop judgment faster than simply asking AI to produce a polished document. Fourth, become excellent at inventor interviews. This may become one of the most important skills of any patent practitioner. AI can generate embodiments. It cannot reliably determine whether those embodiments were actually conceived by the inventor, technically validated, or simply suggested after the fact. A good patent professional needs to understand what the inventor actually conceived, what was tested, what worked, what failed, what alternatives were considered, what is known in the field, and what the inventor believes is actually new. That's not busy work. It's not merely gathering information. It's part of understanding the conception, disclosure, enablement, and claim strategy. Fifth, develop technical depth. Generalist production work is vulnerable to automation. Deep technical understanding is much harder to automate, which means it is far more valuable. And as a professional, you want to be operating where you are most valuable, not where you're a cog in the wheel of a production line. Commodity work and commodity service leads to commodity pricing, and that doesn't pay the premium you should be getting. This means that younger professionals should choose technical areas and become genuinely conversant in them to the point where they're accepted internally and eventually externally as experts. Learn how the systems work, learn what the commercial products do, learn where implementation problems arise, learn what technical improvements matter to customers and competitors, because the more technical knowledge you possess, the more quickly you can identify whether an AI-generated suggestion is brilliant, obvious, impossible, or irrelevant. Sixth, study how patents fail. Do not only study successful patent applications, although you must certainly do that as well. But it is essential to read patents that were invalidated. Read PTAB decisions finding claims obvious. Read cases where the specification failed under 112. Read decisions where claim scope became disconnected from the commercial product. Study what happened and ask which earlier drafting or prosecution decisions may have created the problem, or what could have been done to identify a deficiency earlier. Now, it's not to say that all of the mistakes that the courts are going to point to are going to be deficiencies. Sometimes things do change, but if you are only reading those cases where the patent owner wins, you're missing a great opportunity to identify shifts in practice, shifts in the court's view and judge's view of what's going on, and you're not fully learning the industry. Because the goal is not simply to learn how to obtain a patent. That is easy. After a few years in the industry, you'll realize that if the goal is to get a patent, it just isn't that difficult. If you're dealing with a real innovation and you're willing to layer on specifics and nuances and accept narrow claims, virtually anything can be patented. The far harder task is to obtain patents that are useful to the client. So the goal is not to learn just how to get a patent. The goal is to learn how to obtain commercially useful rights that survive contact with the real world. So what should firms do? I think the answer is to pair younger patent professionals with seasoned patent lawyers in a much more deliberate way. The younger professional may bring greater confidence with AI, a willingness to experiment, speed, and familiarity with emerging technologies. The senior patent lawyer brings judgment, technical skepticism, prosecution instincts, knowledge of what has failed in the past, and an understanding of how the patent office, courts, and clients actually behave in the real world. That is a combination firms should be building. But it has to be a two-way relationship. Senior patent lawyers cannot simply refuse to learn AI and delegate all responsibility to the younger professionals. If the senior lawyers remain responsible for the work product, which they must, The senior lawyer needs to understand the tool's capabilities, limitations, and risks, even if they aren't proficient with coaxing the AI to produce the output in quite the way a younger professional may be. At the same time, younger professionals and patent agents cannot assume that simply because they're comfortable with AI, that means they possess legal judgment. In my view, the winning combination is not a question about youth versus experience. It is experimentation combined with judgment. And on the point of experimentation with AI, let me just say that I've heard many older patent lawyers say that they don't need to learn AI because they'll be retired by the time it becomes important. That is both naive and almost certainly wrong. The technology is improving rapidly. Client expectations are changing rapidly as well. The economics of legal services are similarly changing and very rapidly. A senior patent lawyer does not need to become a software engineer, but a patent lawyer who refuses to understand AI may eventually find that clients prefer working with those who do know how to use it responsibly and efficiently. And that time will almost certainly be sooner than you think it will. And just to be perfectly clear on this point, I'm not saying that patent lawyers will be replaced by AI, but a patent lawyer is likely, almost certainly, going to be replaced by another patent lawyer who does know how to use AI. So while my message is one of extreme caution for those patent lawyers who refuse to embrace AI, for those younger patent professionals, my message is very hopeful. You do not need 30 years of experience to become valuable in an AI-enabled patent practice, but you do need to deliberately develop the judgment that AI cannot provide. Learn patent law, learn technology, learn how patents fail, learn how to question inventors, learn how to challenge AI. Find experienced people who are willing to let you work alongside them, review your work, explain their decisions, and expose you to the consequences of those decisions. And even if you're forced to hang your own shingle, there's always ways to work with a mentor that can be financially rewarding for you and for someone who is willing to mentor you and oversee your work product. In closing, I'll say this. The future does not belong to patent practitioners who use AI to produce the most words in the shortest amount of time. It belongs to those patent professionals who know what should be produced, what should be ignored, what must be verified, and what matters to the client. AI is not going to eliminate patent lawyers, but it will expose the ones who add no strategic value. And it will also create extraordinary opportunities for the professionals who combine technical fluency, legal judgment, and genuine strategic insight.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world, and also be sure to subscribe to our free daily email newsletter.